Yes.
Item number 1.
My Lord, I was praying for the Lordship's indulgence to move an unlisted motion, my Lord. It's a habeas corpus matter, my Lord. But here what happened, my Lord?
You are mentioning,
My Lord, for listing an unlisted matter, my Lord. Habeas corpus petition, my Lord.
but why unlisted?
Habeas corpus, my Lord. We have already filed it. The person has been detained in police custody for 72 hours, my Lord, without production before any magistrate, my Lord.
You will list it tomorrow? Tomorrow.
If Lordship could, it's already been filed, my Lord.
Sorry?
It has already been filed, my Lord.
72 hours, not 72 days. We'll list it tomorrow.
Well, tomorrow.
List it tomorrow as the first matter. Okay. Mr. Mudika, you give notice to the concerned parties.
State I have given, my Lord.
Yes.
I have served a copy.
That is the detaining authority. The state is the detaining authority.
The state police, my Lord.
May it please your Lordship. My Lord, the instant public interest litigation has been prepared before this honorable court, my Lord, bringing to your Lordship kind notice, my Lord, that respondent number 9, my Lord, who is running cement factory, my Lord, engaged in, my Lord, mining of, my Lord, limestone without having mining license for extraction of lime, my Lord. Lime is, my Lord, from lime they prepare clinker is the intermediate for preparation of, my Lord, cement. So the petition, the respondent 9, in collision with, my Lord, other respondents, my Lord, extracting lime, manufacturing clinker, my Lord, manufacturing cement, and, my Lord, availing subsidy amounting to rupees, my Lord, 200 crores, your Lordship. My Lord, I am taking your Lordship to at page 46. First, my Lord. And excess 6. And your Lordship may kindly see query number 1. The mining area in block wise for mining of limestone, shale, so and so, of all the above cement companies mentioned in the subject. Answer is, my Lord, the extent of mining lease granted for limestone in Jaintia Hills of Meghalaya is enclosed as Annexure 1. And Annexure 1 is, here is the list, your Lordship, page 47.
Which is the company against whom you
My Lord, Amrit Cement.
Sorry?
Amrit Cement Limited, my Lord. Others are also, my Lord, that I am preparing, your Lordship. Here, Amrit Cement Limited, my Lord. Page 47, your Lordship will see.
Yes.
And serial number 2, your Lordship will see. Messrs. Amrit Cement Industries Limited. Name of mines, my Lord, it is blank. Extent in hectare blank. Associated mineral granted, if any, no. It is blank. Now I am taking to your Lordship to page 1. This is corroborated by the Ministry of Mines, page 168, my Lord, Annexure 10. And my Lord, this is Government of India, Ministry of Mines, Rajya Sabha, question answered on 12/12/2022. Clause B, my lord, kindly see the details of cement companies which have been given license for mining of limestone in Jayantia Hills. And answer, your lordship will find clause B and C. As per information provided, your lordship has got it, ma'am. As per information provided by the state government of Meghalaya, the details of companies that have been given license for mining of limestone in Jayantia Hills along with their approval production per annum are given as Annexure 1. Annexure 1, page 169, my lord.
What is the consequence of illegal mining?
My lord, consequence is, my lord, if, my lord, because they are using, my lord, explosive blast, and there is a, my lord, act which control, my lord, using of blast, explosive, and it cannot be used, my lord, number one. Number two, if the, my lord, license has not been given, it is now arbitrary, whimsically they can extract to the quantity whatever they, my lord, there is no, it is not required to be controlled by any authority. If it is, license has been given, they have to give details, how much they have extracted.
Your license is not given.
Not given, my lord. And this is corroborated by page 170 also, my lord.
Who are you?
I am, my lord, I retired as a conservator of forest from government of Assam. And I am, my lord, actively interested. Earlier also, my friend was pursuing this matter in applying for Right to Information Act. I have given my details, my lord. I passed LLB also, my lord. Para 2, your lordship will see, page 6.
Who's appealing for the state?
Lord, I am appealing for the state, my lord. My lord, the present petitioner, my lord, he was also involved in earlier litigations. That is, my lord, the matter which was already disposed of, my lord, that is PL number 11 of 2023. If, my lord, I can share a order.
I have mentioned, my lord, about this. My friend filed PIL, and during the pendency of PIL, my friend died, my lord. He
My
expired.
lord, from their averments, my lord, from page number 7, my lord, it is very much clear, my lord, from the averments, if I can read, my lord, the relevant portion. It says, my lord,
It is pending or not pending?
my lord, that matter has already been disposed of.
By what order?
The order, my lord, I have just shared.
The
Because
petition?
petitioner died, my lord.
It is not that.
It concerns Amrit.
Yes, my lord, exactly, my lord. PL number 11 of 2023, filed by
So,
my lord, if I can just read the paragraphs 2 of their affidavits, my lord. The same petitioner, my lord, he was earlier also involved in filing this PIL, and exactly the copy of the same PIL has been filed, my lord, in this case. Now,
this is somebody else's PIL.
this is somebody else.
Yes, where is his PIL?
Present petitioner, my lord, he was behind in the earlier litigations, my lord. That was already.
No, was he a party?
He was not a party, my lord.
Then?
In this case. But from his averments, my lord, he has categorically said.
You apprise us of the regarding the substance of the allegation, not regarding all these
No, my lord.
procedural matters.
As far as this matter is concerned, my lord, we raise maintainability issue, my lord, because as per the
That is the best thing you can do if you have no case on merit.
As per the, my lord, the National
My lord,
Criminal
I-
Tribunal Act also, my lord. As per the Act, my lord, the matter which involves
the report, whether he did it binding with the state. Limestone. That is connected with the full matter. You can do that for a report.
My lord, I appear for 4, 5, 7, and 8, my lord. Union of India, CBI, my lord, and Enforcement Directorate.
Let them file a report with regard to the substance of the allegation.
My lord, in fact, in the earlier petition, the affidavits were duly filed, my lord. But it so happened that the petitioner passed away, my lord, the matter, so that we awaited,
My
my
lord,
lord.
this is,
But now, what has happened, my lord, same counsel, my lord, same advocate, the petitioner has changed, my lord. It shows, my lord, there is something behind, my lord, in the present petition. My lord.
No, we will find out whether there is something behind or not.
and it is only against one particular plant, my lord. Whereas, my lord, if my lord will see the report and close, my lord, the violations
According
are by
to the RTI report, this company has got no right of mining. Now you have to file a report whether he is indulging in mining or not, which would make it illegal mining under the Act and the rules. That's all.
my
My lord,
Thereafter, the court will not kind of monitor an investigation process.
My lord, in the earlier petition, my lord, when the pleadings affidavits were filed, what came out, my lord, that this because there are other miners who have license, my lord, they mine, extract, and sell it to the companies, my lord. So this is how this company is operating. That came out in the earlier.
Page 188, it cannot be done, my lord, as per Act.
You mentioned that in your report.
But the respondent number 6 is not represented, my lord, and the company also number 9, 6 and 9
6 and 9
are not represented, my lord. The notice has.
Will sir,
serve them.
my lord, because there no standing counsel here, my lord. Respondent 9 is private respondent, my lord, and 6 ED, I think my learned friend is appearing.
I'm appearing for 8 months. This Pollution Control Board.
respondent number 3.
3 also notice. 3, 6 and 9.
I think state government.
You are representing 1 to 3,
1 and 2, my lord.
and Dr. Mozika is representing
4, 5, 7 and 8.
We admit this public interest litigation. Full stop. The petitioner is directed to immediately serve a copy of the petition on the private respondent, respondent number 9. Respondent numbers 1, 2, and 3 being the state, respondent numbers 1 and 2 being the state respondents are represented by learned counsel. Stop. Respondent numbers 4, 5, 7, and 8 are represented by the learned Deputy Solicitor General. We also direct service upon the respondent number 3, the Meghalaya State Pollution Control Board, and the respondent number 7 and
6%.
and Northeastern Development Finance Corporation Limited, comma, the respondent number 6, full stop. A comprehensive affidavit of service is to be filed by the petitioner on or before the returnable date. The paragraph, the petitioner claims to be a public spirited person, full stop. Paragraph, the allegation in the petition is about illegal mining of limestone in the Jayantia Hill region. By the respondent number 9, full stop.
Paragraph 3, Your Lordship, may kindly see. Page 8.
On an application under the Right to Information Act made by Sri S.K. Sharma, comma, on 2nd March 2022, the Guwahati Regional Office of the Indian Bureau of Mines under the Ministry of Mines, Government of India, wrote a letter to the applicant specifying a number of companies and the extent of mining leases granted to each of them in the Jayantia Hill region. In an annexure to the letter. According to this information, the respondent number 9 did not have any license for mining limestone. Paragraph. It is alleged that without any license, they are indulging in illegal mining of limestone, which they are using in their factory to make cement. Paragraph. This mining activity is governed by Section 23, inter alia by Section 23, C of Mines and Minerals, bracket Development and Regulation, bracket Act. Again, bracket MMDR Act, bracket close 1957. And the Meghalaya Minor Mineral Concession Rules 2016 and the Meghalaya Mineral bracket Prevention of Illegal Mining, comma, Transportation and Storage, bracket closed, Rule 2022. Framed thereunder. Paragraph. At this stage, comma, before passing any substantive order, we would like to hear the respondent number 9 and the other non-appearing respondents which have been directed to be served by this letter. In the meantime, we direct the state to treat the petition as a formal complaint, comma, make the necessary inquiry and file a report before us. File a report in this court before the returnable date. Full stop. Full stop. It goes without saying that whilst making the inquiry, the respondent number 9 shall also be, in addition to the petitioner, the respondent number, in addition to the petitioners and the appearing respondents, the respondent number 9 shall also be noticed. List this application on 20th March.
If my lord can give little longer period, my lord.
Sorry?
If my lord can give little longer period, my lord, we have to do the inquiry, my lord. If by April, my lord, first week.
All right, 7th April.
My lord. Okay.
Item number 2. There is a delay of 44 days in preparing appeal In fact, what has happened, my lord, we have applied for certified copy on 9th of December and it was not ready. Thereafter, there was long vacation.
Have you served?
My,
Lordship, I'm appearing for the state lordship. We are pro forma respondents here. This is more of a civil dispute, and even for the limitation, my lord, if I may mention lordship, it's best if a notice is first served on the other respondents' lordship.
You have not served.
my lord, because they are private respondents, your lordship. And state, we have already
We are
served.
pro forma respondents' lordship.
So we'll serve, my lord, 1, 2, 4, because there is no standing counsel here, your lordship.
Every litigant must have a standing counsel in the court.
Not litigant, my lord, unless until your lordship will not issue notice, like respondent of 4. This, my lord, the main respondent is respondent of 4, my lord. No standing counsel.
You serve.
My lord, will serve.
This is an appeal.
Appeal, my lord.
All right. This is an application under Section 5 of the Limitation Act 1963 in connection with the present appeal. Praying for condonation of delay of 44 days. In preferring the proceeding. Paragraph. The respondent state is represented. Full stop. The other respondents have not been served. List this application along with the appeal on 6th March. An affidavit of service, stroke service report is to be filed in the meantime.
Much obliged, lordship.
Deeply obliged, my lord.
Item number 3.
An application for continuation of delay in filing the writ appeal, my lord, against the out of and single judge. They filed the reply, my lord,
How many days delay?
176 days.
We are condoning the delay. What do you say?
My lord, there is no specific reason cited, my lord. We have filed a reply, my lord.
In para 4, we stated, my lord, actually what happened in this, instructions were received by my office, my lord, for preparing the memo. I had undergone a surgery, though I have not pleaded that, but that was a personal reason, my lord, in the month of July. And because of that, I was away from my work for almost 1.5 months, my lord. And because of that, there was some delay. After receiving the instruction, I could prepare the appeal only in September, my lord, after I recovered.
What is the impugned order?
But here what happened, my lord, the respondent is an Assam Rifle employee, my lord. He opted for a deputation to National Police Academy in Hyderabad, my lord. So he was given NOC for joining on deputation for a certain period, my lord. And after that also he did not want to come back because he is a resident of Andhra Pradesh, my lord. So he wanted to be absorbed in National Police Academy. He wrote several representations. He went to the High Court of Andhra Pradesh for a direction to National Police Academy to absorb him, my lord. Now, ultimately, my lord, after several rounds of litigation, he did not succeed before the Andhra Pradesh High Court, my lord, and then he had to come back to Assam Rifles after several years, my lord. Now, Assam Rifles ruled, my lord, and in fact, for all paramilitary forces, if somebody is absentee, my lord, the court of inquiry is conducted in absentia, my lord, for unauthorized absence. These are provided under the Act and the rules, my lord.
Thereafter, he was dismissed.
But by Andhra Pradesh High Court, as far as his case for absorption in National Police Academy, it was finally dismissed, my lord. So after that, he had no choice but to come back to Assam Rifles, my lord. Now, when we conducted a court of inquiry in absentia, my lord. Now the learned Singhas was directed to reinstate him and then conduct a fresh court of inquiry, my lord. We were agreed with that because there is no system or no rule providing for reinstatement for unauthorized absence, my lord.
So who had dismissed him? Assam Rifles.
My lord, we are
Not yet dismissed.
not yet dismissed.
Not in dismissed, my lord. It's,
My lord, Learned Singhas has directed that you conduct a fresh court of inquiry against him, but further directed you first to reinstate him.
Reinstate means he must have been removed from service.
My lord, what happens in
the petition,
I'll just complete. Well, what happens in paramilitary force? Well, desertion is a very serious problem. So the Act and the rules itself provide that if somebody goes home or somebody goes on deputation, he doesn't come back on time, my lord. And he avails unauthorized leave of absence, my lord. In such cases, after waiting for a certain period, the paramilitary force can hold a court of inquiry in his absence, my lord, and discharge him from service.
It was held.
It was earlier done, my lord, the learned single judge of this honorable court in earlier round of
Then
litigation.
what happened in the court of inquiry? Discharge.
He was discharged, my lord. The learned single judge held at that point of time, my lord. In earlier
That
round of
means discharge from service.
earlier he was discharged, my lord. Then he came before this honorable court against his discharge also. The learned single judge directed for conducting a fresh inquiry without any direction for reinstatement. Earlier round, my lord. But in this round, the learned single judge is directed to reinstate him, my lord. And we are agreed with only that portion, my lord, reinstatement, my lord.
If he succeeds, he will be reinstated.
If he succeeds, he will be reinstated. But after the court of inquiry, my lord.
Then
my lord,
But the rules, the central civil service rules are not applicable to paramilitary forces, my lord. CCS rules and other state rules, my lord, may provide for reinstatement, my lord, and conducting an inquiry. But paramilitary forces are armed forces, my lord, they are governed by separate rules and laws, my lord.
there should be got out of the component. There's some policy issues are involved with the reinstatement is being authorized leave and all that are paramilitary force. He admitted. Yes. There is a delay of 176 days in preparing the appeal. The appellant has made an application for condonation of delay under Section 5 of the Limitation Act 1963. Full stop. The prayer for condonation is opposed by the respondent. It is submitted that no good ground has been made out, comma, the application for condonation along with the appeal. The application for condonation should be dismissed, and on that ground, the appeal also not entertained. Paragraph. we have carefully considered the Section 5 application. The grounds have been stated in paragraph 4. Full stop. We find that the learned counsel, we find that learned counsel who was entrusted with preparation of the appeal from the impugned judgment and order dated 5th March 2024, for whatever reason, took time from 14 June 2024 to 2nd September 2024. That is to say nearly 3 months to get the appeal ready. Full stop. Furthermore, more than 3 months were taken from the date of the impugned order for the appellant authority to decide whether to prefer the appeal or not. Full stop. Normally, the opinion that an appeal should be preferred comes from the legal department and thereafter approved by the higher authorities of the government. Therefore, the entire period of delay was either caused by no, you cut that out. Therefore, the entire delay was caused by the almost the entire delay was caused in the legal department or in the office of the learned lawyer. Paragraph. It is quite well settled that whoever may be the litigant should not be penalized for any fault on the part of his lawyer. Although in this case, the appellant is the Union of India, the same principle would apply. Paragraph. Moreover, a substantial question needs to be tried in this appeal. whether an employee who has been employee of the Central Security Force who has been discharged from service for unauthorized absence and facing inquiry should be reinstated during continuance of the inquiry. Paragraph. Paragraph. For the above reasons, we condone the delay of 176 days. Full stop. We admit the appeal. We direct the department to register the appeal. Then, as the respondent is appearing, we dispense with all formalities regarding service of notice, etc. We expedite hearing of the appeal. The usual format, paper book by 22nd April. Service on the other side lists the appeal for hearing on 5th May.
Right. Deeply.
Item number 4.
We allow the application.
Wait, please, Your Lordship. My Lord, item number 4 to 18 is an appeal preferred by the state, my Lord.
Yes.
And my Lord, 4 to 18. My Lord, 4, 5, and 6 is listed for the first time for condonation of delay, my Lord, in which I am praying if notice can be issued. Because, my Lord, from item number 7 to 18, my Lord, Lordship, this matters, notice have been issued, my Lord. And in number 7, we have already taken steps to the individual respondents since the council were not willing to accept. And from 8 to 18, we have already served notice, my Lord. My colleague is here, my Lord. They have taken notice on behalf of all the respondents from 8 to 18, my Lord.
7 has refused.
My Lord, in 7, we have taken individual steps, my Lord, to all the respondents, 18 respondents, my Lord, here. And we are waiting for confirmation from the postal, my Lord, certificate.
And number 7.
My Lord, in number 7, my Lord.
And 8 to 18.
My Lord, 8 to 18, my Lord, the previous council were willing to accept the notice on behalf of the respondents, my Lord. So my friend is here, my Lord.
We've received the copies, Your Lordship.
8 to 18.
Yes, Your Lordship.
My Lord, 4, 5, and 6 has come for the first time. So, my Lord, we will have to take steps upon the respondents. However, my Lord, in these 3 cases also,
And 7.
my Lord, 7, the council, as I submitted, they were not willing to accept the notice on behalf of the petition of the respondents here. So, we have already taken steps through registered post, my Lord. So, we are waiting for confirmation certificate from the postal department, my Lord, regarding the status of the delivery of the petitions, my Lord. There are 18 respondents, my Lord, in number 7.
You give the serial number in the order sheet in these matters, like 4 and 5 will be 1 and 2. The appeals against serial number 1 and 2 are appearing for the first time.
My Lord, 4, 5, and 6. Item number 4, 5, and 6 for the
Alright.
first time.
4, 5, 6. There is 1, 2, 3 are appearing for the first time. They are accompanied by applications for condonation of delay. We direct advocate on record for the appellants to serve copies of the applications under Section 5 of the Limitation Act 1963 on these respondents. Paragraph. With regard to item number 7, earlier directions had been made. No, directions had been made earlier. For service of the application on the respondent. What have I said?
With regard to item number 7, earlier directions have been made earlier for service of
Which is serial number 7, huh? See, against appeal against serial number 7. Since the learned advocate appearing for the respondent did not receive service, advocate on record for the appellant has transmitted the papers by post and is awaiting the acknowledgement of service. The appeals against serial (8 to 18) no, the Section 5 applications against serial numbers 8 to 18 have already been served. List all these applications
May I please, Your Lordship? For item 8 to 18, I'll be filing my objection, Your Lordship.
How many days delay?
My lord, my lord, there are different delays, my lord. In item number 8, my lord, 8, 9, and 10, it's 129 days. The remaining is 170, some are 172. So, my lord, different days, my lord. Maximum is, my lord, 183 and 184.
3rd April. The respondents are given liberty to file affidavit in opposition in each of the above applications by 10th March. But is the returnable date fixed? Affidavit in reply may be filed by 2/8 March. That's
Item number 19.
supposed to file the paper book, no?
who's in item number 19?
Well, we have to respond.
We have for the respondent. Right?
Yes, please. Definitely. Hearing matter.
They are yet to file the paper book, Your Lordship, as directed earlier.
You have filed.
They have not filed. We have not received a copy also. Lordship, by the order dated 3/12/24, Your Lordship, the appellant has been directed to.
Mr. Bozika, what is happening in all matters, the government is not filing paper books in time. You please see to it.
My lord, here is a private party.
This is a private party.
You are appearing for a private party.
No, my lord, I'm appealing for the district council, my lord. Mr. Chula is for the state, my lord.
State, Your Lordship.
The appeal is filed by them, the writ petitioner, my lord. The writ petition was dismissed.
Where is the writ petition? Appellant?
This is absent. Mr. Costa Paul,
Mr.
Your Lordship,
K.
because of bereavement, Mr. Costa Paul, Your Lordship, he was bereaved, Your Lordship.
Someone must ask for adjournment.
Someone must have been.
Should mention that he is appearing in the matter.
Absolutely, Your Lordship.
This appeal is adjourned. Till 5th March, comma, on the personal ground of Mr. Paul, learned advocate.
My lord, I think Mr. Paul will be
1 month.
for a month he'll be away, my lord.
1 month.
Because the mourning period is 1 month he informed.
1 month.
So it can be in second week of March sometime.
Second week of March.
Second or third week of March. Because what happened is uncle also passed away, and mother also passed away within a week's time.
Seventh April.
Lord. Highly of
Item number 20.
Comma, by consent of learned counsel for the party. Yes.
Item number 20.
May it please your lordships. My lord, this is the matter where a fifth-year LLB student was not allowed to sit for the exams, and my lord's order, he was subsequently allowed to sit. He has appeared in his exam. Today, I must crave little indulgence of my lords. There was a direction for me to prepare the paper books, my lord. Through oversight, I could not prepare. So kindly give me a week's time, my lord. I'll prepare paper book. My lord.
What is the stand of the university now?
My lord, so far university is concerned, my lord, we have a relevant regulation, my lord. Now, regulation has prescribed the requirement, my lord, what are the percentage.
No, now he has written the examinations.
My lord, it has been
So, you want to pursue the appeal to cancel it?
No, but only thing, my lord, my concern will be, my lord, whatever we have incorporated, my lord, this is in pursuant to the directives issued by the Bar Council of India. So, my lord, only thing, my lord, perhaps we'll insist that this should not become a, my lord, in future cases, my lord. Because there are certain, my lord, regulation which say, my lord, the stipulated requirement is this.
Time to file the paper book in terms of our order dated 5th December 2024 is peremptorily extended till 4th March.
4th March, my lord.
List the appeal for hearing on 10th March.
10th March.
Lordship, may I plead, my lord? Only in the, my lord, first and second week, my lord, I have some personal difficulty. If it may come up after 14 March.
Then paper book 7th,
7th.
let it come up on 20th March.
My lordship.